Hello everyone, here. I'm Professor Dong-Suk in charge of the Korean Constitutional Law at Ajou University Law School. My affiliation on the program is marked incorrectly. I ask for your understanding. Thank you for the opportunity to present at this conference. On the other hand, it is said that I couldn't meet at Central University of Chile. And I'm not good at using English. So I read the prepared manuscript. Uh, yeah. Uh, this is table of contents. Mhm. I became interested in the right of nature when I came across Thomas Berry's Earth jurisprudence in a group called People for Earth Forum. I have been interested in various human rights issues in social reality as a constitutional researcher. However, as human rights have been institutionalized within the state system, I have often faced a phenomenon in which human rights are reduced and distorted rather than realized. While a human rights-based approach is very important, I felt a sense of shame that human rights were merely declarative claims and could not change human life unless the state system for institutionalizing human rights was reformed. Of course, it is an experience in Korean society. In Korea, as jurisprudence and rights of nature were recently discussed, uh, constitutional discuss a book titled Jurisprudence for Earth was published. Constitutional complaints were filed with the Constitutional Court regarding the climate crisis and legislation to establish an ecological cooperation for Indo-Pacific bottlenose dolphins in Jeju provincial government. However, even if the discussion on the rights of nature began not long ago in Korea, I felt that recognizing the subjectivity of nature was not enough to cope with the climate crisis and the ecological crisis facing the Earth. There are two concerns. One is, what is the content of rights in nature's rights? If the concept of human rights does not fit nature, it is a question of what content should be included in the concept of rights. It leads to the question of how to view nature as the subject of rights. I think the content of rights should be discussed first before the recognition of the subject of rights. Sorry. Ah, sorry. Yeah. The other is the question of how to construct Oslo, starting with Oslo. How can we overcome the limitations of existing weak international law in the reality of harsh international politics and of capitalist system that seeks economic profits first? I didn't get the answer while preparing for this presentation. However, I wanted to share my concerns about establishing a global legal system to guarantee the rights of nature. For scholars from various countries who discussed the rights of nature earlier, this issue could be a preliminary discussion. I believe that if Earth law is a matter of establishing norms that encompass all human beings on Earth as well as non-human beings, unequal progress is inevitable in the process. The narrowing these differences will be the way to create the Earth law system. Natural rights and rights of nature. For Locke, natural rights is the freedom of man to act as he deems appropriate and to deal with possessions and person within the boundaries of laws of nature in state of nature. The state of nature is a kind of social state in which free and equal humans live in various relationships and form one group or another. Natural rights can be realized only when a society such as a state of nature is created. But reality is not free or equal at all. And the meaning of nature at this time is a human abstraction that is different from reality. The reason why the state of nature may not be a state of self-indulgence or a state of war is that natural law binds all humans in the state of nature. This is because humans can know through their own reason the natural law that to all mankind humans are all equal and independent beings, so no one should harm other people's lives, health, freedom, or possessions. For Locke, human freedom is based on the fact that humans have reason, and both freedom and reason are original to human. However, natural law is not universal or general binding. Natural law does not contain a normative relationship between human and nature. Human reason is that nature is an essential requirement for human existence, but it is destroying its basis of existence by harming nature. Human reason forms its essence through historical process. It is not known whether the historical direction is optimistic. However, humans only try to head in a positive direction. I think right of nature is a concept that extends human natural right to nature. All this at this time, nature is a concept objectified to human and is completely different from the state of nature before human society. It is paradoxical that nature was invited to the world of human ideal right to restore the nature destroyed by humans. In a society, state, and international system where human rights are not properly guaranteed, it is difficult to understand whether nature can be guaranteed rights corresponding to natural rights, and furthermore, what rights guarantees can be recognized. Oslo, just by looking at few simple data or reports, you can see the situation of the climate crisis. The Earth's problem cannot be different from country to country. The Paris Convention recognizes that humans have had a significant impact on Earth system since the Industrial Revolution by increasing fossil fuel use, increasing carbon dioxide emissions, and increasing global temperature by increasing the concentration of greenhouse gases in the atmosphere. A Korean situation skip. Yeah. By the way, the damage from the climate crisis are unequal. Today, the responsibility of the countries that have accumulated wealth and the responsibility of the countries to grow in a long or short period of time. South Korea grew industrially in a short period of time and had a significant impact on the climate crisis. The abstraction of human and life concepts does not help solve the problem. It is responsibility of all humans, but not all humans are equally responsible. The victims are all humans, but the extent of the damages is not the same. Responsibility and damage are not proportional and in some cases are inversely proportional. South Korea is currently largely responsible, but the damage is relatively small. As a person living on Earth, the responsibility of the society and the state in which I live feels great. It is a matter of responsibility that must be done to solve the Earth's ecological crisis. Specific legal responsibilities between countries should be discussed in terms of distributional justice, and accordingly, citizens of each country must commonize the norms and principles of ecological law and pressure their governments as sovereign to do so. I think this is the one of the ways of to create a system of the Earth's ecological legal system from bottom to top. So the gap between the time to accelerate the climate crisis and the time to respond to it is remarkable. Some predict that it is exceeded the tipping point. In South Korea, the resolution of the climate crisis is linked to economic growth and is not out of its subordinate state. Policy and legal responses are taking place leisurely, as if we have a lot of time left. So I came to think about how to commonize the norms and principles of other countries that are ahead of ecological legal action. It was also a matter of incorporating the Earth's jurisprudence, which had just begun to be learned, into the South Korean law system. It's necessary to find a way accelerated actual legalizations. Even if the rights of nature are legally recognized, it is obvious who will judge them. Under such conditions, nature is subject to humans. In ecological law, it is necessary to deconstruct the concept of rights itself based on will or interest. Resistance is to try to change rights and laws while being outside rights the laws. Although there may be the large variation from country to country, it is probably not very different in most countries in terms of the ecological preservation of the earth. Even if a country has good ecological legislation, it has no choice but to have territorial limitation in the current international legal system. So it is necessary to redefine legal rules and principles. For example, the best international principles of the earth and of the ecological law governance to the highest level possibility. These principles are derived from the principles of guaranteeing children's human rights and health rights in the international human rights law. Perhaps projects are needed to commonize the ecological law provisions for the Earth's peace in countries around the world. These ecological law provisions are not a state sovereign monopoly norm, but the Earth's commonized norm. It is an approach based on a legal system that forms a combination of the best ecological law principles and is necessary to commonize ecological science and technology, not economic aid, not economic aid or the development. So I'll skip this part. Yeah. Oslo Projects. One of the definition of the concept of Oslo is as follows. I want to ask these questions. Is the Oslo Project a task to attract nature into the realistic human rights system on the premise of an ideal world of nature's rights? Or is it a project to build a system of the earth that can foster the relation of coexistence, symbiosis, and co-evolution with nature in the trend of destroying nature on earth? At this time, my concern is what the relationship between humans and nature is now in reality, and how to adjust it in a present and future from the perspective of the Earth's law. Human laws are different from law of rule of nature, and the two sometimes lie in a multidimensional relationship of compatibility, inclusion, exclusion, and overlap. So, yeah, so in the case of embracing the rights of nature by Oslo, Locke's concept of resistance rights can be borrowed. Embracing nature with the earth law does not completely lose or exclude the rights of nature. Human society must and actively guarantee the rights of nature, taking the meaning that the rights of nature are as essential as nature law or more. The right of resistance, defined by Locke as the right of the people, becomes the content of right of nature in the earth law. For Locke, the right to resist is a right as a group, and nature's right to resist is a right as a group. Yeah. I propose communizing of the resistance to the Earth's crisis. Uh, I'll pass. I'll skip this part. Sorry. Uh, yep. Figure 1 shows the current legal system that is normally understood as follows. The rule of law makes it ideal to control the international and external discretion of the state. However, the reality of the legal system that I think of is shown in figure 2. Areas that cannot be regulated by law exist extensively in and out of the country. Recognizing the rights of nature can be a declaration of the current legal system as shown in figure 3. If you understand the law in 3 dimensions, the inside and outside of the law are in the same space. In the current legal system, pushing nature into the subject of rights rather risks strengthening the existing anthropocentrism legal system. So I wrap up what I am saying now. Oslo is a hybrid law that harmonizes human law with law of nature. Who is the legislator of the earth law? Who is the legislator who confirms the laws of nature? Does the subject of legislation exist? Without the subject of nature, what would interpret the rights of nature and how would it connect to human law? These questions are questions that cannot be solved in the existing human legal system. Perhaps many countries have formed and found legal norms and principles if they are influenced by each other. Now, it is necessary to promote the revision of the written law in an ecological direction, recognize the advanced ecological norms and principles of other countries uh, as the ecological law of the earth and accept them as norm that people living on earth should respect. It is also a process of reaffirming the resistance of all beings and their solidarity are sources of law that must be commonized and used on earth. I think the solidarity of ecological laws that make it so is the foundation of the Earth law commons created by people on Earth who desperately want ecology and peace on Earth. Yeah. Yep. thank you very much for listening. I'm not good at English, so I'd appreciate it if you could send me a text message for comments or questions. Thank you.